Apologies, we have to cut into that. The Chief Justice nominee, Justice Anin Yeboah, is being vetted by the Appointments Committee of Parliament. We want to take you there now live.
The court about Article 296, which I want to read. Where in this constitution or any of the other law, discretionary power is vested in any person or authority, that discretionary power shall be deemed to imply a duty to be fair and candid. The exercise B of the discretionary power shall not be arbitrary, capricious, or biased either by resentment, prejudice, or personal dislike. It shall be in accordance with the due process of law. N3. This is not about anything, but I'm saying that when a case came to the court on exercise of constitutional instrument with the EC about bringing the constitutional instrument by the Constitution in coming out with constituencies so that we know that they are acting partially. The Supreme Court made a ruling that if all bodies that are supposed to come with constitutional instrument are being told to enforce that, there will be a nuclear, there will be a nuclear meltdown. And that was given by a lead, what do you call it? Lead justice. And I find that I link it just with the minority leader statement. Since we haven't seen even the judiciary exercise their constitutional requirement since 1993, it's just Justice Her Eminence who has just laid a paper. Do you think that we should oblige, we should make it mandatory for people who exercise such extreme powers, breadth and depth, to follow what the Constitution is saying?
Thank you, Mr. Chairman. I think the first case which comes to mind was the West Africa Examination Council case, West Africa Examination Council versus Awuni. Yes, and her ladyship, who is just leaving us, made it clear about the exercise of discretion. Please, even in judicial proceedings, where we exercise discretion, there should not be unjudicial exercise of judicial discretion. Yes, so when it comes to administrative authorities, they are also enjoined by the very Constitution to be very careful not to be exercising discretion which appears to be very capricious and, I mean, without any basis whatsoever. But then, if you read the whole article, please, the statute should not be issued. Yes, see. Yes, it says where the person or authority is not a judge or other judicial officer, because judges give reasons. Yes, you are enjoined to give reasons for the decision you've taken. Whereas administratively, yes, that is inapplicable. But then if one insists that for every authority, for every person who is exercising an authority beyond the exempted ones should come out with, I mean, reasons for exercising that discretion. Yes, please, we are in for complete absurdity. Yes. For example, if...
yes, I agree. So you do agree that for other administrative bodies, that it's even more imperative that they publish this?
Oh, no, not in all cases, Mr. Chairman.
When the Constitution so requires?
Yeah, yes. For example, if you are head of an institution and on a regular basis, somebody's appraisal report shows that he is performing very, very well, but then on a regular basis he is not, for no apparent reason. If he goes to court, the court can compel you to show cause why, regardless of the person's performance, you certainly, consider others over and above him. And that would be a good development of the law. So I think Section 296 should be read as a whole, just as every statute should be read as a whole. And then you probably appreciate that if the discretion is exercised without basis at all, then that could be questioned.
That is precisely my question, yeah. Whether that administrative body has been exercising that for a long time, precedent has been set. But if somebody is going to court to say that what you are doing is not fair, so let us show the basis, then the court should not, I believe, should not be on the side of that administrative body. It should be on the side of the ordinary citizen who wants to affirm his faith in the Constitution. But even if it's wrong, the reason why I'm asking the question, which still has not been answered, these lead judgments and lead counsels, how does the Supreme Court reform itself when you see that there are cases that has come that what probably the court, the panel portended has not been what has been delivered in the lead justice council? I'll give you an example, arbitrary. The 5 members sat and said, Mama Yarga is right with this case. The court, then you go and write a lead counsel and give it to lead judgment and give it to Obi Amwa. How would the court reform itself?
Mr. Chairman, I think the question is incomprehensible, with all due respect, because you see, when arguments are heard in open court, we retire to a conference to consider our decision. It is there where we brainstorm, and maybe if nobody is dissenting, we settle on some issues, and somebody may volunteer when he has some knowledge of that area, because we cannot all be equal in all areas of the law. Yeah, so if you read some of the judgments, you see my sister, who is just leaving us, always interested in developing the constitutional law and expanding the frontiers of what the Constitution should be. Justice Datima was also one of our prolific writers and whatever. But all of us consider the judgment, we read the judgment, we go to conference and consider the issues before maybe one is delegated to write it. Yes, so...
that is my question. Please yes. Listen to my question. I said, when you have gone to conference and all 4 have agreed that this is where the case should go, and the lead judgment, which has been done on your behalf, because in other Supreme Courts, everybody will write his or her judgment. But we have adopted a procedure when lead judgments are the ones that are read. And I'm saying that if it so happens that the lead judgment is not the reflection of what happened in the court, yes, how is the court itself going to go through the process of amending the fault?
My Lord, I think the practice is that order. When one person, one judge writes the judgment, the others read it and they indicate, I agree. Some even write additional. And if you disagree, then you write the dissenting judgment. It's only on a few occasions in recent times that they each write independently. So the practice is the verdict is agreed, then one person is elected or volunteers to. So if you have another question.
Thank you, Mr. Chair, for bringing clarity. You have explained it this way, so I'll take your explanation. But it was a question meant for my incoming Supreme Chief Justice of the Supreme Court of Ghana. So I'll leave it there. Your explanation is enough for me.
Yeah, Honorable Halu.
Thank you, Chairman, and may I join my colleagues in congratulating the nominee for the nomination. My first question is something we've talked about over and over, and it's about clogging of the court system. It is very frustrating to take your cases to court, and also very expensive in the long run. Her ladyship, remember when we were vetting her, she lamented a lot about the needless delays in the justice system, and also the obstacles that face the system. What will you do differently? Is there anything you can do to make justice available and also not expensive to the ordinary person?
Thank you, Mr. Chairman. Please, in the short to medium term, I think we have to build more courts. Yes, if you get to the Equipment Ridge, when you leave Adenta, where the president commissioned the court quite recently, please, the whole of Equipment Ridge, which is heavily nucleated, settled, you have only 2 courts. One magistrate court at Mampong, then the circuit court at Ekropong. Beyond Biru, Ukugwa, and all those places, they don't have courts. That is why we are very, very eager to put up more courts so that the people will access justice. I mean, when justice is close to them, they don't waste time. Some of them can even go to the court and even go to the farm thereafter. Because we have a problem. When you even pass the Kumasi road, you will leave a Jabin, which I think was recently closed down. The next place you can see a court is Amasamai. And look at the population in between. Urbanization brings with it petty larceny, maintenance, and paternity issues, and all these things, and they all come to court for redress. And mind you, Ghanaians are litigious. No 2 ways. We will want the judge or magistrate to decide the case for us. When we even want to promote
that's why there's
ADR
in the country. We will always defer to higher opinion and will comport, will abide by it.
We are trying to encourage Ghanaians to also resort to ADR, which is a less expensive way of resolving disputes, so that you do not just litigate to the chairman of the Legal Aid Commission. Fortunately, this year you were given a warrant to engage more lawyers, and we are opening legal aid clinics all over the country. So if you have a district there and you think you need the legal aid assistance, please, you provide us with accommodation. We will send the personnel in. Just last 2 weeks, I think we opened one at Dwaso, where Professor Tifa furnished the place for us. And it's about maybe 20,000, and the people go there and settle petty disputes. Yes, and it takes a chunk of the cost load. You go elsewhere in advanced countries, Mr. Chairman, they have wide array of administrative tribunals taking part of the cost load. But here, even the rent control officers cases that the rent control officer handles is nothing, because ultimately the parties appeal. The parties appeal. Then you go to maybe Labor Commission. They are also helping us with labor disputes. Beyond that, we have very, very few and non-existent administrative tribunals to take part of our process. Madam, we are very anxious to build more courts. Now we have some money ready, and within a very short time, we will go to the hinterland and even in Accra here. But another problem is that it's very difficult to get short. Yes.
Okay, my concern really was about the adjournments in court. You go to court today, it's adjourned for another 1 month, another month, and it goes on and on. So that is really what I'm worried about, not the distance, but the adjournments.
Mr. Chairman, if the courts are many, obviously they will be sharing the load. Yes, if the courts are many, they will be sharing the load. So that if the cases are evenly distributed, and for just 1 day, as in America or elsewhere, a judge has just about 3 cases. Obviously, if he starts sitting at 9 o'clock and to close at 4 o'clock, he will certainly complete the cases on time. Yes, but here is a problem that we have, and we are trying to address it by raising money to build more courts, employ more magistrates and judges where the workload is too much, the lower courts.
Yeah, thank you, Chairman. My second question is about the process of nomination or nominating the Chief Justice. When your name came up, a few comments were made here and there about political coloration. But we want a system that is clean, neutral, and fair to everybody. So political coloration is a big issue. I was looking through the literature, and I saw the Kenyan example, which I thought was quite okay. I don't know if you are aware of that. Otherwise, let me just explain the Kenyan system. That once there is a vacancy, there is a competitive process. All those who qualify apply, they are shortlisted, they go through interview, and at the end of it all, the president only formally tells us who has qualified or who should be the Chief Justice. And that will require some amendment to Article 144 of our Constitution, which is talking about seniority and all that. What do you think about this? What is your view about that?
Madam, I've never, sorry, Mr. Chairman, with all apologies to honorable member, I have not looked at the Kenyan example which the honorable member is citing. But then here is our constitution, and we went to referendum and adopted it. I think if we want to change it, we should resort to the procedure and change it. But then what happens is that in respect, as regards the other judges, please, the bar can propose you. That was proposed by the bar. Yes. I never applied. My Lord, there are so many people who didn't apply.
My Lord, we are satisfied with your answer. Well, please go on.
The last one, a very simple one. Your ex-wife, Her Ladyship Avril, will be on the bench with you. Do you foresee any professional dilemmas? Just that.
Mr. Chairman, no, we are.
Yeah. You tell us. But we want our women.
Allow him to answer.
Me?
Regulate how people ask questions here.
Why? But we want.
My Lord, do you foresee any dilemmas?
I don't foresee any dilemmas. It's a simple one. And I want women to have opportunity.
Mr. Chairman, with due respect, no. Yes, we are professionals. Yes.
All right. Honorable Esla.
No.
Thank you, Mr. Chairman.
Order. Honorable Esla, it's your turn.
Mr. Chairman, the name is
Sorry, Honorable Esla Owusu Kufu. I should have recognized the change. No, sorry.
Thank you, Mr. Chairman. Mr. Chairman, I wish to congratulate the nominee on his deserved nomination. And safe to say that we expect that the same standards that is applied in the course of his professional life, from the bench, the bar through to the Supreme Court, would be exhibited in his role as Chief Justice if this House approves his nomination. And judging by his conduct at the committee so far, I have no doubt that we would recommend his approval to the House. So I wish to congratulate the nominee and leave it at that.
Honorable Dacha.
Mr. Chairman, I did say that I have no doubt, based on his performance, that the committee...
what is your issue now?
I'm being accused of prejudicing the committee. I am expressing an opinion.
Honorable Minister, thank you very much. Honorable Dacha.
Thank you, Mr. Chairman. I am gladdened that the nominee has some powerful record. I've not heard anybody saying that this is gratis. His competence is known. I've also not heard about any deficit of integrity, and I'm very confident that he's going to deliver when he's approved. I want to start with money matters. Mr. Chairman, in terms of Article 1793 of the Constitution, and with your kind permission, I'd like to read. The Chief Justice shall, in consultation with the Judicial Council, calls to be submitted to the President at least 2 months before the end of each financial year, and thereafter, as and when the need arises. A, the estimates of administrative expenses of the judiciary charged on the consolidated fund and Article 127 of this Constitution, and estimates of development expenditure of the judiciary. 4, the President shall, at the time specified in Clause 1 of this article or thereafter, as and when submitted to him under Clause 3 of this article, cause the estimates referred to in Clause 3 of this article to be laid before Parliament. 5, the estimate shall be laid before Parliament under Clause 4 by the President without revision, but with any recommendations that the government may have on them. The development expenditure of the judiciary, if approved by Parliament, shall be charged on the consolidated fund. I want to find out from the nominee that when you pay regard to this, I've been a member of the Judiciary Committee for some time, that this provision is observed more in the breach than its compliance, to the point that the judiciary is starved of money to do its serious business. One area of concern to me is how you apply your IGF. Would you want to say that by reason of this breach, which has deprived the judiciary of good money to do its serious business, you should have the benefit of 100% of your IGF in order to do...
Member, ask another question. My Lord says 50% will do for them. So ask another question.
Oh, I didn't hear that. He said, oh, if he should have 50%. Okay, that's all right. Then let me ask another question. Yes. Well, let me follow up from that. Nominee CJ, do you think, having regard to the fact that the local assemblies are unable to give you some infrastructure support, 50% will be sufficient for you to do serious court development? Because now you're talking about courthouses just in the background of people cooking meals and the rest of it, and also how the justices are accommodated. Do you think 50% will meet your developmental agenda?
No. Mr. Chairman, half loaf is better than none. See, there was a directive way back in 1995 or so, when I think Professor Hoy in comply. Apparently, it wasn't backed by any law. But the district assemblies should know that it is their business to put up calls for us. In any case, all over the world, it's the executive which provides the judiciary with infrastructure. You build a court and maybe a bungalow, 4-bedroom bungalow for a circuit judge. He will be okay. So you have that problem.
Well, Lord, if you can afford to, you should be content with that. 2 bedrooms should be sufficient.
But please, some of them join, Mr. Chairman, some of them join the service late when they are within their 50s and they have about 4 or 5 children. So that if you want a circuit judge to live comfortably, and you give him maybe 4-bedroom bungalow, he will be more than okay for the purpose. But Mr. Tajian, we plead with honorable members of this house to encourage the disassemblies to even invest more. When you build one court, as I cited the example of the Yendi court, it was there for close to about 100 years. You do periodic renovations, and that's it. Yes, so please, it's a passionate plea from the bench, from the judiciary, that the district assemblies should do more than what they are doing. Yes.
No, yes, too.
Mr. Chairman, I want to refer the nominee to Article 1283 of the Constitution, which provides, with your kind permission, I'd like to quote, "A Chief Justice shall preside at sittings of the Supreme Court and in his absence, the most senior of the justices of the Supreme Court, as constituted, shall preside. My Lord, this provision has been given several interpretations. And the one which is very clear from this provision is that you are in duty bound to sit on every case unless you are not in the jurisdiction. That is what it means at his absence. Or maybe you are challenged because of ill health. Is it your understanding that your weight should be felt in every case that comes before the Supreme Court, or you can excuse yourself even when you are in the jurisdiction? You can excuse yourself even when you are in the jurisdiction.
Mr. Chairman, I think that the provisions of the article which on a particular case, then he presides. But then it could be that for some reasons, the Chief Justice decide to recuse himself from the case. If the Chief Justice declines jurisdiction to sit in a particular matter, then the most senior will preside. Because the Chief Justice's duty is very enormous. If you look at 1253, she is just the administrator and also a sitting judge, 125 clause 4. So it's a combination of both, and the Chief Justice cannot, always be there to preside.
I think what the emphasis he wants to is, what's the meaning of in his absence?
I think his absence means when he is absent from the panel, not from the jurisdiction. Yes.
That should be. Yes, you have your last one, or you're done. One more. Nobody told you that. If I say so, then it's so. Please.
Mr. Chairman, Alan Deshowich, who is a Harvard professor of law, Alan Deshowich, who is a Harvard professor of law, in his magisterial book, Contrary to Popular Opinion, posited, and I want to quote what he said: "The American bench is a benign retirement from the rigors of private practice." My Lord, do you think there should be demonstrable evidence of success in private practice